Our sponsors, as usual, are Easy Law Construction Notices, the Blue Book, Ventura County Credit Union, Builders Book, and the Ventura County Contractors Association. We appreciate their support in bringing you these educational seminars, and I hope you find them useful. My name is Stephen Sanders. I'm an attorney. I'm going to be touching on issues today that are of legal nature. Obviously, I'm not giving legal advice on any specific issue. You can't rely on anything I'm telling you for general information. In solving your own legal problems, you should contact our office or hire another, competent construction attorney to assist you in handling those issues. But we remain here happy and ready to help you out in dealing with the design build issues, the legal issues that may come up when you get into these projects. We would prefer, though, that you would include us at the very beginning and help you set this up right. There are 8 attorneys at the Green Law Group. We primarily work in the real estate and construction areas. We also do a certain amount of work in employment. We represent a lot of businesses and their employment needs, and also deal with employment claims. We do some bankruptcy creditor work, typically trying to get contractors paid, which we seem to do most of the time. That's our primary occupation here. These are the attorneys at the Green Law Group. So let's talk about design build and what the general legal issues are. There are various delivery methods, you would call them, in terms of how contractors and designers approach projects. Design build has kind of a corollary, which is design bid build. Sometimes these design build projects, you will enter into a contract for a sum uncertain, but there's a commitment to construction in the beginning, and typically a control estimated budget and control estimated schedule that the project will follow. That sometimes will mean that at some future point, the contractor will submit a committed budget. And so that becomes, a design build project. Sometimes, though, that second phase, so to speak, is not committed in the original contracting, and the contractor merely submits a bid on their own design. That can be fairly complicated. Design bid build is there are some disadvantages and there are some advantages. Certainly to the owners, there are advantages in that they have a contractor that's, approaching the design process up front and looking towards buildability, potentially, maybe assisting them in some of their permitting and entitlements in ways that contractors in particularly are capable of doing, maybe more so in many respects than architects or engineers. But the lack of commitment and the requirement that the contractor bid usually would require bidding within certain parameters before it would be let out for additional bidders. And those limits or scope, should be set forth in the contracts to differentiate it as a design bid build versus a design build contract. We may get into some of that more as we go forward. So what is design build? Basically, the builder is hired to design and build. Normally, that's a large construction company. I'm beginning to see more architect-driven design build projects, but I have issues with their legality, particularly in the sense that architects are not hired to build anything. That's not in their bailiwick, and they're not licensed to build anything. And so, I think one should be careful if you are an architect or a designer entering into a contract where you're responsible for building, because you do not want to act in the capacity of an unlicensed contractor. So you can't take money for a construction project for anything other than design. So, that complicates things. But in those contexts, sometimes you'll see the architect serve as a construction manager, and the trades are directly hired by a developer or owner or entity if it's an agency. And, there are ways to structure an architect-driven design build project, but I'm primarily not going to be talking about that form of design build contracting. The one I'm going to be talking about today is primarily contractor focused, where the client is hiring a contractor, an agency is hiring a contractor to do the design and do the build. One consideration is there are a set of legal authorities that require builders, contractors who design plans to only do so for themselves. In other words, they can't act and intrude into the role of an architect. And so that creates some complications where the designer of the project is a contractor who writes plans, maybe stamps plans for the authorities. And those plans then, they're for the purpose of the contractor, subject to contract. You do not want contractors just merely entering into design contracts exclusive of the build, or for the build to be determined later. I would even, have to have special language in a design bid build context to deal with the transfer of the plans in the event the contractor didn't land the project. So those factors need to be considered. The one surefire way for the contractor to protect themselves is to hire licensed architects, typically as independent contractors, and preferably in most instances. Certain in-house work may be, that may be a good way to go, but there are disadvantages to doing everything in-house. Where companies are going to be doing a lot of in-house design work, I would encourage them to set up a separate entity, use that and separately contract with that entity. Certainly, if you were to hire me to set this up, we would talk more about, the insurance issues related to that and why you need separate entities. I won't get into that and digress, but, setting up a design shop for a contractor takes thought and consideration and a fair amount of paperwork. You should also be careful about your marketing. I have a lot of clients that do design build work, particularly on residential, marketing your company as a turnkey builder has come back to haunt many contractors that I've come into contact in litigation over the years. Turnkey is a specific industry term. You need to be very careful about using it. The concept typically means that, yes, you're going to design it, then you're going to build it. But it also means that you're really warranting the use of the building. You're typically going to also be doing furnishings, potentially interior design. I mean, it really is, the concept is, you sign the contract and a year later you turn the key and walk in and start your operations. The contractor is really buying a lot of potential liability and issues if they're going to go to those extremes. And if you're going to set up a turnkey company or a turnkey project, if you're even going to use that term, you should be talking to a lawyer before you sign the contract. And if in fact you are advertising or marketing as a turnkey contractor, you need to think seriously about how you're making those representations and make sure that you make those representations on your website and elsewhere on a limited and very conditional basis. feel free to call me to talk about that too. Okay. So, changing. Technical difficulties here.
Okay.
No, it just goes backwards.
It's not doing this.
Okay, so we'll just use that. By the way, is our PowerPoint showing up in the presentation?
Yes.
Okay, just wanted to make sure. The PowerPoint, you can request the PowerPoint. We'll be happy to send it to you after the discussion. So when you're sitting down to contract for a design build, form of agreement matters. The two types that I deal with commonly in a design build context are AIA forms and consensus docs forms. If you're not familiar with these, you probably should be, particularly if you're going to be in a design build universe. They're kind of the gold standard for this. If you're going to do a Frankenstein form for design build, and I use that term meaning it's written by a lawyer, cobbled together based on various other forms, etc. You would probably use one or the other of these as a model, and it's still important that you understand how these forms are used, because many of the provisions that you're going to use are probably going to come from these forms. They are different. I would suggest that in my experience of the design build contract forms in consensus docs, I would typically probably use those in smaller to middle-sized projects, anywhere from probably, 100,000 to 7, 8, 9, 10 million. AIA, with the amount of detail, for their design, owner's requirements and the various design phases and things that are going, I would typically not use that in a residential context. I would only use it in a commercial context, and I would probably only use it on a very big project of, at least 5 million or more. Other very smart lawyers can disagree with me on that, but the administrative expenses and demands of the AIA forms, the architect-driven forms are pretty high. And I think that the consensus docs forms with a more simplified process with the owner's program is probably better for the smaller projects. So what are the difference? Well, the owner's program typically is not set forth at the initiation of the contracts. It typically is something that the owner would provide in an initial kind of pre-design phase or consulting phase, and you would typically set up the compensation for the design builder in gathering the requirements or the owner's program for the design. So you can do this, you can do the pre-phase consulting, the design, and the build all in one contract form, okay? Or if the owner is not really willing to commit to the project, you can set up a separate consulting form where you would act to engage with the owner in figuring out the interaction between the build for the facility and the design and build of the facility with the owner's uses and requirements. Particularly if the owner is not entirely sure what that program or requirements are going to look like. So, you know, you want to make sure that you limit and clearly express in the design build undertaking what the owner's requirements are if you're making any financial or time commitment, any cost or time commitment. Then you need to have a very robust set of owner's program documents or requirements. You should have click on it. Okay. So, you know, you should consider, you know, what's the scope of the owner's use? Do you require entering into some kind of process or feasibility study? Okay. Do they know that the building is going to be fit for their use? Will they pay for conceptual or schematic drawings? You know, what kind of scaled space do they need? What are the uses? What are the special equipment that you're going to be handling? You know, I had a major arbitration last year on issues in a design build project where the owners had designed certain spaces for drainage requirements and chemical handling and solids, et cetera, for manufacturing process. And in middle of the project, they changed their minds about where they wanted all that stuff to go, and all of that had already been constructed. So during the course of the project, the owner's program or requirements changed, and then, you know, conflict ensued. So, you know, the time that you spend in really nailing down these programs and requirements can really help you avoid confusion later, and we will talk about some of the conflict issues as we go. Conceptual and schematic drawings, in my mind, you know, should do more than just show you a pretty picture of a building, okay, in an architectural, you know, rendering, representative rendering, you know, or models. You know, you should understand what the spatial components are, you know, for entry and exits to various rooms, space requirements. You know, you should understand where all the power is going to flow, where all the air conditioning is going to flow. You should probably take a long look at your mechanical and electrical plumbing needs and make sure that the space is going to meet it. You know, if the client has a current facility where they're undertaking to do work, you know, similar to what they're going to do, or, you know, either manufacturing products, process, or retail, you can go look at that and you can gain ideas. But you also need to differentiate and communicate clearly with the owner what the differences are going to be, how it's not like the facility that they're already operating in, what their expectations are for the new facility. I've litigated situations where there was an assumption in the early design build design process and what that the owner's requirements would be consistent with their existing facility, and it turned out later on they were completely changing their processes and all the things that were required, and so there was a lot of confusion around it. So you want to nail all that down early. And if you're going to go and visit and inspect their current operations, you also need to set expectations that it's not your responsibility to go through and map every single thing that you're going to see. It's really the owner's responsibility to provide the information to you for their program and requirements. If they don't provide it to you, you know, they shouldn't be relying on you, you know, gathering by osmosis or observation, you know, whatever the necessary data is on their current operation. Nobody knows it like they do. Okay, so You also should pick your team early. And in order to pick your team, you really need to understand, these processes, the feasibility, what these conceptual drawings may look like, what the current operations are, what the expected operations will be, so that you can pick the right team that may have specialties or experience in those areas. And the team members are your designers, they're your architects and engineers. They may also be consultants. You may need, dust or air handling. You may need flammable or fire consultants. You may need other people depending on what the processes may be. Often one of the big ones that should probably be looked at earlier than it is fire suppression. You may want to bring a team member in who's a specialist in fire suppression and sprinkler systems, because often that will dictate uses and you'll need additional space to handle them. And so that should be, if it's going to be, they're going to be issues of flammability, maybe you want that early. You also need to figure out your pre-contract time and compensation. What are you going to get paid to do all of this investigation of the owner's program and requirements, okay, and to review it, potentially to do early bidding, to create a conceptual estimate or do unit pricing in your estimating, in order to even build a conceptual estimate of budget or time. It's also probably a good idea to bring in, because at anything like this where it's both you're responsible for the design and the build, you probably also want to bring in a scheduling consultant, someone who can set up your CPM path schedules early. And most of these things need to be built into either your contract in the main, so that these costs are reimbursable and recoverable, or a consulting contract if you're not signing your prime contract for the design build process yet. And what's the time? You should give a labor rate sheet. Make sure that you include a project executive. If you're the owner of the company, you're going to have to spend time on it. As well as your project managers and estimators, so that you are able to get compensated for that. And then you should give, maybe a realistic estimate for the amount of time that it will take you to do what you need to do, but that needs to be based on in a clear framework of what it is that you'll be doing, and that needs to be agreed between you and the owner with clear lines of separation. Whose responsibilities are what? Am I going to be responsible as a builder to figure out your use and feasibility for your operations? Probably not. Okay, and so normally team picking should also include who's going to be on the owner's side, and are they competent to actually do the work of interfacing on the build conditions, and do they understand the operations well enough to make sure that, that everything that the builder wants to do and the designers want to do is comports with the use and operational requirements of the facility. So what I've called phase one here is really is when you've signed the prime contract, you've already gone through the consulting process, and you have your team. You may even have at this point commitments of architects and engineers and other consultants, which are conditional commitments on the owner signing the prime contract. Meaning that if he doesn't sign it, then you're not committed to any of these designers. And then you're taking the early conceptual schematics and the owner's program or requirements. You've documented the owner's approval in writing of all of those. And now you've attached those to the prime contract for the design build services. And now you begin to prepare the plans, drawings, and get ready for planning submission. Again, this contract, the prime contract, is going to be the tool by which you set forth what your responsibilities are versus the owner. So you need to expressly carve out who's responsible for the design work, and the design work is strictly for building, and what the scopes of that building, at least conceptually, are at this point, which would probably attach the conceptual schematics. You would also separate out any owner requirements, which requires owner performance separate from the design builder's performance. And those owners' performance requirements are typically things like special zoning, certain clearances, permitting requiring additional agency involvement. Sometimes that's AQMD or the local air quality district, or whichever county you're in. Again, fire suppression. Those are things that that the owners should be processing early, getting design builder input as needed, keeping design builder in the loop, but ultimately are the responsibility and liability for the owner unless the contractor is promised a turnkey build, or promised to at least perform those functions. If a contractor comes to me and says they want to, be responsible for the use permit for instance, a brake pad manufacturer, I'm going to tell you, you're out of your mind. Okay, you don't know their business. There's all kinds of environmental factors and what they do. Okay, why would you involve yourself in all of the regulatory issues that they need to deal with? Those need to be their responsibility, and that needs to be carved out for them. But if I have a client who, has built lots of brake pad plants before, and they have some skills, and they are willing to hire the right consultants to make sure that, and they're getting compensated for that, then I may go, okay, those are risks that you're prepared to bear. Ultimately, contracts are risk shifting devices. That's what they're there for. But first, you have to acknowledge what the risks are, make sure they're set forth in the contract, and then assign, whatever the responsibility may be. If you don't do that, congratulations, design builder, you've just bought the problem. Okay, so your contracts need to clearly set forth what the owner's performance requirements are, or you very well likely they're your problem. Okay. Conceptual estimated budgets and conceptual estimated schedules in the early design process evolved. You need to make sure that you are providing them to the owners and that the owners are signing off on them. If you are not getting cooperation from the owner, there needs to be a termination provision to get you out of the deal. Okay. The contractor should be being compensated for their time in the design phase, in managing and coordinating and supervising the various designers who hopefully are all licensed professionals. And ultimately, if you're not getting what you need from the owner, you need to be able to pull the ripcord and get your parachute, okay, and land safely on the ground and not crash with the plane. So negotiating your contract in the design phase should give you that parachute. There should be some kind of basis whereby you could terminate. If you don't have that, you're in danger of being stuck, potentially building a project that you really never got the design off the ground on, so that the design is constantly in flux and in turmoil, and you never really did know what you were committed to build. That's a bad place to be. Speaking of which, we would talk about what's the phase two, what's the construction process going to look like? Is it going to be a cost plus fee, where you have uncommitted time and uncommitted costs, and basically the contractor tells the owner what work needs to be done, gives them the estimated budget. Maybe they even track a schedule of values against it, but there's no commitment to the cost or time. There will just be, change of work notices and authorizations from the owner as things develop. And then if the contractor is not receiving those on a timely basis authorization, there needs to be a ripcord, termination by the contractor, because ultimately they're not getting cooperation from the owner. Certainly the owner is going to have termination provisions too if they're not happy with their contractor. But in a cost plus fee environment, everybody's kind of responsible for their own performance, and there's no major commitment on price. In particular, with a lump sum or fixed price contracts, and sometimes it's sometimes it's required. I would tell folks that are doing design build residential work on behalf of homeowners that if you're doing a design build remodel, you have to follow home improvement contract requirements under the statute. So you are not allowed to do a cost plus fee. You have to do a committed lump sum or fixed price on any residential remodel. So that's not true on new construction, but it's true on a remodel. So I do know that a lot of contractors and a lot of owners don't like that. They want a cost plus fee, and many of those contracts get written on residential remodels and often. But as the contractor's lawyer, I would tell them they're making a mistake. And particularly on a design build project. Design build is very common in residential because the owner does not want to hire an architect. Architects are expensive. And frankly, a lot of these projects, and particularly the residential remodel projects, they're not big enough to warrant an architect's involvement, and a lot of architects don't want to touch them. And I can't say that I really blame them. Okay, so residential remodel design builder needs to get errors and omissions insurance, as we're going to talk about before, but they also need to stay focused on conversion of a non-committed estimated budget during the design process, which then becomes a committed lump sum budget once the plans and permits issue. So that particular transition needs to be carved out carefully in the contract. If it is not, it's a train wreck. Okay. Again, you need a competent lawyer who understands design build context, hopefully, to assist you in that, unless you have a lot of experience in doing it. But even if you do, don't keep repeating bad mistakes, even though they don't turn out necessarily badly for you every time. All you need to do is catch one wild project, and that can really set you back. So typically in commercial, we see a lot of cost plus, and then we also see some lump sum. A lot of the time though, cost plus will have a guaranteed maximum price if it's going to be a commercial project rather than just straight lump sum or fixed price. It's a smaller project. The guaranteed maximum price is complex because, and particularly in the design context, because you don't have a design, you have a set of plans or permits to build a max price on, right? So you can't really make that commitment initially. It has to be to be determined once the plans and permits issue. So you have to make sure you're carefully writing that into your contract. Ultimately, it is perfectly possible to do that, but that really, to do a max price contract, but understand that the cost plus nature of that means that all of your accounting and your payments to your subs and everyone is disclosed. It's a big commitment for a contractor not You want to make sure that you have a good sized contingency. You have rights to move the contingency. You either need to own any savings or at least split the value of savings. You should also consider if there's a liquidated damages clause, which there often is, a cap on liquidated damages. And when you're negotiating that max price, because I will tell you, these projects take on a life of their own. If you do not have these, again, parachutes or exits that are necessary to protect you, there can be in a good sized design build project, there may be, bankruptcy potential for that contractor and a max contract. So, proceed carefully and preferably with legal counsel. One problem I see is everybody's in a rush to get to work in a design build project. And so a lot of times the owner wants you to start demoing before you have committed design plans, et cetera, and you don't have permits. So they'll say, well, go get a demo permit or go get a temporary permits for this, that, or the other thing. I'm real leery about that. I've seen it go haywire. If you do demolition on a project and you don't have a committed design and you're never able to get to a committed design, there's a very good chance you just committed waste and devalued the property. If I have a client who wants to do that, I'm going to tell them, look, you need to get a waste waiver. That the owner's taking responsibility if you're not able to get the design work, and that needs to be expressed in writing, and there needs to be an indemnity for that. The other thing you need to be concerned about is there existing financing on the building, and are you committing waste on the lender's property and devaluing the property from the existing mortgage? I mean, there are a lot of pitfalls in early work, and you need to know what you're doing. You need to be conscientious about it. Frankly, you should probably also consult your competent construction lawyer who handles these kinds of things. One of the biggest problems that we have in post-permit construction processes is the continuing changes that the owner wants and documenting them and keeping up with them. You should be tracking your submittals, your plan submittals. You should also be tracking your owner's supplemental information requests on their finish activities. And you should be tracking that all in the log, your submittal log, supplemental information log. Make sure that you are then translating that to money and time in a meaningful way, that your change orders track your submittals and supplemental information. To the extent that you need additional design input, you would submit requests for information. Now remember, you hired the designer, right, as the builder. Owner didn't. So requests for information need to go to both the owner and your designer, okay, because your designer needs the authorization from the owner in order to proceed. You cannot miss that step, and I've seen it done on numerous occasions where the contractor receives the supplemental information request to change this, or sometimes it's an owner's change directive, okay? And the contractor takes it on themselves to do whatever that change is, okay, and don't involve the record architect or engineers. Well, oops, okay, you have the duty to coordinate and manage the design both before the construction and during the construction, okay? So do not stop that coordination activity, after the construction process starts. Make sure that where there are significant changes to the project, that the architect or engineers are brought along and are brought to the party, because otherwise you're giving up some of your potential shield and cover, for not having those designers involved, and the owners you become their fiduciary of the design in many respects. in a design build context. There's case law. Okay, so you cannot make that mistake in the context of design build. The other thing that comes up a lot is scheduling. I've talked a lot about money, and I've talked a lot about the exchange of information. Scheduling is complicated because the issue is whether it's committed or uncommitted. But it's a good standard in practice, even in an uncommitted time context, for the design builder to be providing construction schedules. They should also have provided a few design schedules, and then once the construction starts, then they should be providing construction schedules. That's a good way for them to properly coordinate, supervise the construction work. Whether those schedules are committed or not is a creature of contract. You need to make sure that the contract says one way or the other. If they're uncommitted, then you still need to use these schedules to put the owner on notice of changes. They should be shared with the owner, okay? The more information you provide to the owner, the better. Puts them on notice of all kinds of things that they need to be responsible for. So, in a perfect world, you would have perfect communication of the design requirements and the owner's, the owner's program, that would then be communicated to the designers in a way that they can then formulate building plans that are consistent with that, as well as the use requirements for the permitting. And then you would get to a point and the permit would issue, and then you would begin, at that point, reset your budget. Even if it's an uncommitted budget, you still want your estimated budget to be consistent with the plans and the drawings, okay? And to the extent that there would be changes based on those costs, you want to put the owner on notice of that, okay? Whether it's committed or uncommitted, okay? You don't really treat it much differently, frankly, okay? And that also, there should be sufficient money in the general conditions cost to pay you for that update, to bring the estimated budget current with the, or committed budget current with the plans and designs, okay? That would typically, in a committed context, generate a change order. If it's not a committed budget, then it would generate a change to work authorization, at least a notice to the owner that there's going to be more money and more time, or there's going to be less money and less time. Hey, maybe you look gold, okay? But once that process is done and the construction starts, that's when you really begin to understand whether or not you've done a good job of bringing everybody to that point, because that's when you find out whether you had unclear or unrealistic expectations on the part of an owner or any of the designers, okay? And you want to smoke that out early. Part of the process of updating the budget is to figure out where the disconnects are and what happened, okay? And you don't want to get deep into the construction process before you figure that out, okay? Because the owner may want to go a different direction. And, and there may be, if there's been ineffective collaboration to get you to this point, now would be a really good time to do it before there's been a lot of money expended, in the construction process. There's also a very real possibility that you've been dealing with some incompetence here and maybe you didn't even realize it. Maybe the owner's representative, might be great, but just unversed in what the owner's operational needs were. Maybe that wasn't their role. Maybe they're the CFO and they're from the accounting department or something, okay? Rather than their facilities supervisor or whatever. The wrong people have been in the wrong place to get you to this point. Hopefully, you would have headed that off. The other thing that happens sometimes is the owners want their own construction manager or the agency, and their construction manager is looking at this project and he's been watching it going through the design process. And I hate to say this, but I've been in situations where licensed contractors serving as construction managers became, what I call the white knight syndrome. Oh, well, this guy, I mean, he's just done this, and that, and, you should really hire me to take over this project. And that can happen at any point during the process. Those kinds of communications break down because you have an actor in the communications acting in bad faith. Okay, you want to deal with that early. You do not want to let a project develop with that kind of personality involved, and you need to reevaluate where you're at in the project when that starts to happen. And that, that builds distrust and creates issues of distrust between the owner and the contractor. During the course of the construction, defects happen, I won't say it. It's for a family audience, but you get it. So, defects happen, and when you're the design builder, you own the defects. But now it's more complicated because now you've got to differentiate the design responsibility from the build responsibility yourself and attribute it accordingly. Now, the good news is you control the designer. So if you can do a workaround, you can typically get the whole thing handled in-house, and you're not in an adversarial relationship with the owner, which is one of the great advantages of a design build process. The adversarial relationship is merely between the owner and the design builder. There's no design team intermediary, okay? They work for the contractor. So, buck stops with you, okay? That can be very effective in dealing with these issues as long as you're on top of them. Bring the designers to bear, get your subs to work effectively to correct the problem, okay? The problem, though, becomes when the design, quote unquote, defect relates back to an owner's omission, either in the use requirements or their program, and then it gets more complicated. And so the more robust communications you've had from the consulting phase through the design phase through the build phase, and the records that you keep, okay, matter incredibly in any future conflict. They're the difference between winning and losing, okay, practically every time. So I can't stress enough, minutes, and minutes that track changes, have by-when dates, have detailed information. Maybe they track the divisions so you can relate them back to the scheduling of CSI divisions. You should be doing all of your budgeting through CSI divisions. All your change orders should be through CSI master format divisions, whether it's the old system of 16 or the new system of 55, I don't care, but make sure you're tracking everything so you can look back on it, okay? If you are maintaining good minutes, that's good. If you're having telephone conversations with people, send them a quick email, memorialize the communication. So in the distant future, people can look back and there's some documentation of what was communicated. Don't rely on people's memories. They're driven by their expectations, and their expectations change. And so conveniently do their memories. And that's true on both sides. Design build does also kind of create some new unusual warranty situations for builders. Most builders don't really deal with design, right? It's just not in their universe, okay? And design warranties matter, Designers have to have sufficient experience. They need to be licensed properly. You need to make sure you track their licensure. They may have certain authority from you, and you may want to limit their authority, okay? It may be that you want to limit their authority with their communication with the owner, direct, right? Maybe you need to be copied on all those communications. They work for you, they don't work for the owner. Your design warranties will be set forth in the prime contract. You may also want to consider them in any consulting context too, because you want to make sure that you are limiting your warranties to a very expressly laid out and specific set of minimum standard of care. Okay, so if you are new to design building or you haven't really dealt with these warranty issues before in your design contracts, you should probably be talking to a competent construction lawyer and making sure you're cleaning up your act on the design side, which is unfamiliar to a lot of builders. They treat design build too much like a regular old project where they just drew up some plans. Just draw up some plans. That's design build. Yeah. Okay. By default, your contract should reference and reflect the work you do. Okay. Signing a prime contract where you provided the plans and there's no design elements in the prime contract, it's a pure construction contract. That's a big mistake. Okay, big. So, as far as the construction warranties, they're pretty much the same as what you deal with. You want to think of your fit and finish responsibilities under Civil Code 900, and other statutes. You want to make sure your workmanship is free of defects. That's true for design. That's true for construction. Products warranties and if there are products that were specified by the owner for their own use, they should probably be buying those direct and handling those warranties themselves. If it really is going to be close to turnkey, products warranties, require limited assignments, okay, where you've purchased their equipment. You want to do limited assignments even though for the fixtures that you install and build process. But make sure that when you do limited assignments, that they are limited, that you retain your indemnity rights so you can go after the product suppliers if they give you a faulty product and you get blamed for it by the manufacturer because, quote unquote, your installation wasn't right. Okay, well, that happens, but it doesn't happen as much as the products manufacturers would like us to think. Those are typically dealt with, those assignments at project closeout, along with your manuals and all of your other information transfer. On a design build project, you're going to have your typical, you'll typically have a 1-year callback warranty. That's under the AIA general conditions, I believe includes a callback warranty. You may want to seriously consider entering into a maintenance agreement on the property with your, that you've built out. Maintenance agreements allow you to, when you're dealing with callback issues, you can address those, and you can separate your responsibilities for maintenance from warranty repairs, okay? Because there's kind of a, there's a lot of times what happens is contractors give extended warranties. I don't like extended warranties, and I like short, limited warranties as your lawyer. Okay, and if you really want to give them, some kind of good marketing boost, then you can do a maintenance agreement, right? And give them a discount for the first year or two, and then extend it out. So if you want to do extended warranties, think instead of a maintenance agreement. The other big bugaboo here that design builders deal with is the insurance mess. A lot of folks out there doing residential remodel design builds or even new residential construction design builds, and they don't even have any insurance that covers them on the design work, which is insane. They're relying on their licensed architects and engineers to provide insurance. And what I would tell you is, and many people don't realize this, but most of these design insurance products are burning limits, which means that all the money they spend on defense burns up the money that's available for covered claims. So they're typically just litigation. They just pay to litigate. The lawyers get paid, nobody else. So, you as a design builder can't rely on those types of policies to pay you anything. Okay, so you need to have your own burning limits design policy set up for your shop on an errors and omissions basis. Now, there are construction managers and consultants insurance, and it may be that that's really all you're doing is acting as a consultant or a construction manager, coordinating the efforts of these other licensed professional designers. And that's fine, but you can have that and carry it, and you should, particularly if you're acting in that capacity. But understand that's a burning limits policy typically too. Okay, and so ultimately it's probably there's not going to be a lot of money there unless you're careful to pay for claims or legitimate design defects. You typically run the same build insurance. You want to make sure you've got a good, strong commercial general liability insurance. You want to make sure the coverages are for the gross value of the project. Okay. Make sure you have enough coverage. $1 million, $2 million is not going to cut it on a $7 million project. Okay. Talk to your broker. Employment practices, liability insurance, EPLI is a good thing to have. Builder's risk is essential, which is of course a construction insurance to, particularly on any remodel. You want to make sure that you've got good coverage because you can't rely on the homeowner's insurance to bail you out of a fire on a construction project. You should also consider wrap policies, owner controlled or contractor controlled. If I'm the design builder in particular, I probably want it to be contractor controlled. And if you guys need referrals to good, competent insurance brokers that can handle these products, then by all means, let me know. I think we're getting to the end here. A lot of AIA contracts have a designated neutral provision, and I believe even the consensus docs do too. Architect is not your designated neutral. Okay? He works for the contractor. Frankly, I don't even like that in the AIA and a regular prime contract because the architect works for the owner. You're better off just picking some smart guy somewhere that understands construction and can be a neutral if there's a dispute, try and work it out. Okay. Assist with the mitigation, and if you need referrals to people who can serve in that capacity, I'm happy to, provide it. I believe strongly in mediation and arbitration. I believe that the mediation and arbitration participants clause should be included in the design contracts and all of the subcontracts. Also, there's the sticky issue of the owners own direct contractors that aren't you. You as the design builder should be controlling the site. The owner should not be hiring people to work alongside you. That is a recipe for an unmitigated disaster. I've seen it over and over again. You control the site. You hire the contractors. If they'll give the owner a break, they're only giving them the break through your coordination and supervision. You should not be allowing the owner to get in, bring these folks in. And if you are allowing the owner to bring this in, they need to get their own insurance. They need to pay for their own site improvements and site conditions, in temporary site improvements and site conditions. They need to run their own, shop, so to speak, on site, and they need to be separated from you. And then they need to have a duty to coordinate with you and the owner on their activities so they don't interfere with yours. And that all needs to be documented in the prime agreement. And again, do not do design work with draftspeople. Use architects, use licensed architects, use licensed professionals for everything you do. There are reasons for that. There's a time and a place for an owner to hire a draftsman to do up a set of plans. But understand that if they're not licensed, you as the builder, you're the license on the project, you bought any of their defects. Congratulations. So be leery about involving anyone that doesn't have a license, okay? because you just bought that problem. I would also point out that the law limits the design professional's duty to defend. It used to be that they would sweep design professionals into these big design defect cases, bring them all in, and then, you know, argue joint several liability or whatever. But the courts frowned on that in the Senate. Bill 496 a couple years back laid it out that, you know, they'll only pay your defense costs, you know, on a proportionate percentage of fault. And boy, is it hard to get to their proportionate percentage of fault. You have to spend a lot of attorney's fees to get there. And a lot of times you're over guessing what the real percentage of fault was. And you unfortunately can't write around it. So again, you should have a lawyer reviewing your design contracts. And if it comes to an issue of duty to defend and indemnity, you know, we do a lot of coverage work here. We deal with a lot of insurance claims. We assist contractors in tendering those claims. We do bad faith work where carriers are not picking up the defense or they're denying coverage. You know, Jeff Coiner in our office is real strong in that area. You know, I've got years of experience in it too. So if you're having those issues, you're welcome to bring them to us. We'll be happy to help out. So that's my show for the day, so to speak. I am available for any questions if anybody has presented any, but the good news is I'm so thorough that I've already answered all of your questions. So I don't have any. I'll give you guys just another 30 seconds here if you want to type something in, if there's anything that I raised. Well, I don't see anything coming in, so by all means, if you, on second thought or upon reflection, any questions come to mind, you can reach me at the phone number there or the email. Feel free to write it down. You know, I'll be happy to answer your general information questions on this topic, or you can retain us. We can go to work for you. Okay? Thank you for your time and attention. Good luck.